Hello students, welcome to Satva Academy. So in this video I will be discussing second unit of the company law, that is legal status and types of registered companies. So here in this chapter you can expect around 5 to 7 marks question. The important topics are corporate personality, perpetual succession and common sales, private limited company, dormant company, government company and OPC. And again I will be discussing 3 questions here, and I will attach the PDF copy in a description where you will get more question and answer and also the revision sheet for your upcoming exams. You can get the advantage of that. Okay, before going to the question, let's understand about the corporate personality. So what is corporate personality? Here when you form your business under company form of business, you will get the artificial personality. So here artificial personality means it is a juristic person in the eye of law. So the advantage is, once you register your firm as an artificial personality, once you get the certificate of incorporation, automatically you will get some rights to that artificial personality. Under that, first one is contractual capacity. By using that you can carry any business or else transaction, and also you can carry the business. The main advantage is, here it will enjoy the separate legal entity status. Here separate legal entity means company is different, shareholders or employees of the company is different. So even though they are working for the company, still they are separate from the company. Here the liabilities of the company is always paid by the company and not by the shareholders or as the directors of the company. So that is what the advantage in case of corporate form of business. So that is the reason why people prefer company form of business for their business, because it avoids the liability for the investors. In some cases, even though the company met with the loss, and company may have to pay some liability, and that liability will be paid by the assets of the company and not by using the shareholders' money. Clear? So that is the advantage in case of corporate form of business. Okay, let's analyze the question. See, Mr. Kumar, a successful entrepreneur, converted his proprietary firm Kumar Engineering Works into private limited company. So now that option is also available. When you are carrying a business under any form, you can convert that to company form of business, but you have to comply with some legal provisions. So after that you will get the legal personality for carrying your business. Here Kumar did the same. He converted his business from proprietorship firm to company form of business. Okay. And he gave a name, that is Kumar Automation Private Limited. Okay. Next, the company formed with his wife and son as the only members. So in his company also no other members from the outsiders. All the members belongs to his family only. Then Mr. Kumar sold his business to the new company for 1 crore rupees. As a consideration, he received fully paid up shares worth rupees 40 lakh. And secured debenture worth rupees 60 lakhs. So there is a consideration for selling his business to a newly formed company. So this one is possible. Being a artificial personality, it has a contractual capacity. By using that contractual capacity, it can make a contract with the shareholder and it can buy the business of the shareholder also. So that is was a transaction made here in this question. Okay. Next, which were secured by floating charge on all companies' assets. See here for the secured debentures by the shareholder, that is 60 lakh rupees, as a security, company's assets were attached. Okay. He held 98% of the company's total share capital and was its managing director. Now Kumar is the person who is holding 98% of shares, and also he is a managing director. He holds a position as a managing director in the newly formed Kumar Automation Private Limited. Okay. See, company suffered huge losses and went into liquidation. At the time of winding up, the company's total assets were only 70 lakh rupees. Now the problem is, when you are closing your company, you have to close by following the winding up procedure. So during that process you have to settle the liabilities of the company first. After that you can close the company. For settling that liabilities, you can use the company's assets or as properties of a company and funds available in the company. Okay. The liabilities includes Kumar secured debenture 60 lakh rupees due to unsecured creditors 50 lakh rupees. Now the total is 1 crore 10 lakh rupees. So that is the liability. Then next, unsecured creditors argue that company is merely an alter ego of Mr. Kumar, and they contended that they should be paid in priority to Mr. Kumar's debenture. See, now you have to suggest, examine the validity of the unsecured creditors claim and advise the priority of payments citing the relevant legal principle and the case laws. See, in normal cases, what we think, if the major shares is held by the company's owner himself, and if he gives any loans, then we have to give the priority to the outsiders. So this is usually happens in all other forms of business. When you are carrying any business under proprietorship, then you have to use your personal property also for paying the liabilities. But the advantage of companies, whenever you are carrying your business, then if you met with the loss because of the uncertainties, then you need not to receive the liabilities of the company. Here the unsecured creditors claim is that they are thinking that Kumar made a business form just to cheat the outsiders. But the thing is, the loss is because of the uncertainties. There is no wrong committed by the Kumar here. He was actually carrying the business. There is no intention to commit a fraud. Clear? Okay, let's see the applicable provisions for this case. Kumar Automation Private Limited being a valid incorporated company, it can enjoy the separate legal entity person from Kumar. Its major shareholder and managing director. So even though the Kumar is a major shareholder and managing director, still company can enjoy the separate legal entity. It means company is separate from the shareholders and directors. So whatever the transaction carried by the company will be under the company name itself. Here also unsecured creditors gave the loan to company and not to the shareholder or else the director of the company. Okay, fine. Next one. See, here you can also give the citation of Salman case, which is already given in your textbook. See, Salman case. So these facts are almost similar to Salman versus Salman case. In that case also you got the decision in favor of the separate legal entity. In that case law you can find that the company should pay its liability while winding up of the company. So that is, company should settle his secured loans first. After that, if remains any surplus, then it can go for settling the unsecured loans. So that is what the procedure to settle the liabilities of the company. Here you need not to consider the legal status of the person or else any other provisions. You have to follow the rules of the company law while settling the liability. That is what the judgment given by the court. Okay, let's see the applicable provision for this case. Okay, see, Mr. Kumar's dual capacity as a majority shareholder and secure debenture holder is legally valid. See, you have to find, is there any fraudulent intention to commit any crime? In that case, you can lift the corporate veil and make natural person who is acting behind the company, we can punish that natural person who is acting behind the company. So here there is no personal intention to make any fraud or else crime, so that here he can enjoy the separate legal entity status for his company. Next one, in his capacity as a secure creditor, he has contractual rights against the company for the repayment of his loan. Even though he owns the major stake of the company, still being a creditor, the contract made with the company is valid contract, because he gave a secured loan, that is 60 lakh rupees, by attaching his company's assets. Now the principle of separate legal entity protects the rights of the creditor just as it would protect any other third party creditor. So here the creditor may be shareholder or else may be employees of the company or else may be a third party. Creditor is a creditor for a company. Now there is no partiality between those status of the creditors. You may be a shareholder of a company or else you may be a director of a company, still you have a right, you can make a contract with the company to give the loan. So here company will treat everyone equally. The duty of the company is to settle the secured loan first, and after that it can go for settling the unsecured loans. Legal provision applicable for this question. See first one, the thing is here you can apply the separate legal entity concept here. After incorporation, company becomes juristic person, distinct and independent from its members, as highlighted in the text. See here, according to the rule of company law, the company formed by the Kumar is a valid company and it can enjoy the juristic person, and it is different from its shareholders and directors, so that its duty is to settle the secured loan first, and after that it can go for the unsecured creditors. So the same judgment given in the Solomon case also, that you can quote in your answer if you remember any case studies. So that will be a weightage for your answer also. Try to remember any case related to the similar concepts. Okay. Here a member can also be the secured creditor of the company and is entitled to the same rights as the other director in that capacity. So as I said, here even you may be the shareholder of the company, or else you may be the director of a company, you have a right to give the loan. Once you make a contract with the company and you enter into a loan agreement, then you will enjoy all the rights of the creditors and you can claim against the company. Here you will get the compensation. Okay. Now let's see the conclusion for this case. So this is the conclusion to be given in this question. See, the claim of the unsecured creditor is invalid and will not succeed. In accordance with the law of insolvency, secured creditors have preferential rights to be paid from the assets over which they have a charge. So you know the charge concept. Whenever a company wants to take any loan, they have to create a charge on its assets, and it was pledged to creditors loan. Here, according to the insolvency law, company should pay the secured creditors first, and after that if remains any surplus, then after that it can use the surplus amount to distribute it among the unsecured creditors. Here preferential rights will be given to the secured creditors and not to the unsecured creditors. Here according to the facts given in the question, you can distribute the assets. See, here Kumar is entitled to receive 60 lakhs from its available assets of the 70 lakh, and you can use remaining 10 lakhs to pay the unsecured creditors. So this is what the suggestion you can give it to the company. Okay, let's move to next topic, that is dormant company or else inactive company. So what is inactive company? If any company has not conducted business or else significant transaction for 2 years, such a companies will be treated as dormant company, and that company can apply for the ROC for allotting the dormant status for its company. Now the thing is, for that it has to fulfill some compliances. After fulfilling the compliances, you can apply for the dormant status for your company. Okay, let's see the question. Okay, let's analyze the question. See, Bhavishya Nirman Private Limited was incorporated on April 1st, 2022. So with the object of acquiring land for future real estate project. Due to delay in the regulatory approvals, the company has not commenced any business operations since its incorporation and has not made any significant accounting transactions also. Now the board of directors now wishes to apply for the status, that is dormant company, to minimize their annual compliances cost. Now you have to advise them. Before that, there are some conditions. See, some other facts is also there in question. Okay. See, these are facts given in a question regarding the company's transactions. See, first one, prosecution initiated by the income tax department for non-filing of the return for financial year 2022 and 23 is currently pending before the authorities. So this one is a drawback. Then company has an outstanding unsecured loan of 5 lakh rupees taken from one of its directors, but who has verbally agreed to the company applying for the dormant status. Here he got the consent but verbally. Then third point is, an undisputed demand for property tax of 50,000 payable to the local municipal authority. Now, as a company secretary, you have to advise the board of directors whether they can go for the dormant status, or if they apply, then what will be the stand of the ROC, that you have to suggest in your answer. Okay, let's see the legal provision applicable to this question. See, according to the section 455 of the Companies Act, here you can find the meaning of the inactive company: one that has not conducted business or made significant accounting transaction for 2 financial years can apply for the status to the registrar of company. So if you don't make any significant transaction, or else if you don't carry any business activities in your company, such a companies can apply for the dormant status in ROC. But for that, there are some other provisions also there. You have to follow those provisions. See, let's compare it with your facts given in the question. First one is, no prosecution has been initiated and is pending against the company under any law. So according to the section, there is a pending suit against the company. The next one, there are no outstanding statutory taxes, dues, or else duties payable to any government or else even local authority also. There should be a no default of payment towards tax or else any other payment to the government or else local authority. Then third one is, there is no outstanding unsecured loans. The company must obtain lender's consent and enclose it with the application. That means here, in case of any unsecured loan, they should get the consent from the creditors and it should be attached with the application. That is the compulsory provision. But here the company took only verbal consent from the unsecured loans. So by seeing all the facts, you can consider it as the company will not get the permission from the ROC. Okay, let's compare it in a analysis part. Okay. See the problems in this question to the Bhavishya Nirman Private Limited companies. First one, there is a prosecution pending against the company by the income tax department. So this one is a drawback. So by considering this point, you cannot apply for the dormant status. So then second condition is, the company has an undisputed and outstanding property tax demanded by the local authority. Clear? So this is another drawback. And unsecured loan related. While the company has unsecured loan, these issues could potentially be resolved by obtaining the written consent. So this one you can take, but the problem is there is 2 ineligibilities. Because of that, your company will not get the permission from the ROC to convert your company status into dormant company. So that is the conclusion to be given in your answer. See, despite being an inactive company, now Bhavishya Nirman Private Limited currently not eligible to apply for the status of dormant company because of these ineligibilities. So one thing is pending suits before the authorities and pending dues of the tax to local authorities. So that is the 2 ineligibilities that restricts from applying the dormant company. So this is what the conclusion to be given in your answer. Okay, next move to the next topic, that is OPC, one person company. So this is a special kind of company where if a person wants to start his business for a small transactions, or else if you want to start a business instead of sole proprietorship, he can go for the one person company. He can enjoy the separate legal entity status in case if he form the company under one person company status. So here 100% stake will be held by one member. So that is the feature of a one person company. Miss Priya, an Indian citizen who resided in India for 140 days during the preceding financial year, wants to incorporate one person company. She has following plans. Primary business of one person company will be to engage in a non-banking financial investment activities Second one, she intends to appoint her 17 years old son Rohan as the nominee. Then third one is Miss Priya is already a member of and sole owner of the another OPC, that is Priya Venture Private Limited. See, these are three conditions. Now you have to compare it with the legal provision whether Priya is eligible to apply for the one person company. So that is the suggestion should be given in your answer. Okay, let's see the legal provision applicable for this question. See, this is the legal provision. First condition is a person cannot be the member of one or more than one OPC at any point of time. That means a person can incorporate only one OPC and not more than one OPC at a time. So here from first point itself she is ineligible because she already has one OPC. Okay, second one, OPC is prohibited from being incorporated and carrying out non-banking financial investment activities, and the object decided by the Priya is also invalid. The reason is here NBFC activities is prohibited by the company law. So one person company cannot carry the NBFC activities. That is second ineligibility. Third one is the nominee appointed by the member must be eligible to be a member. That means he should be a major person. According to the question, her son is 17 years old, still he is a minor. A minor cannot be appointed as a nominee in a one person company. The problem is, in case of any uncertainties, if a member dies, then the nominee should take over the company. To take over the company, the person should be a competent person. A minor is an incompetent person according to the Contract Act. So that the nominee mentioned here in the question is incompetent person, so that she can't name her son as a nominee for the proposed one person company. So there are three ineligibilities in this case, so that you can give the suggestion in the conclusion that here Priya cannot form another one person company. That will be the conclusion for this answer. See, first requirement, that is residency requirement. Here Miss Priya stays in India for 140 days. The requirement is only 120 days. Though she fulfills the first criteria, but there is an ineligibility in second or third criteria. Second one is existing membership in another OPC. Priya already have Priya Ventures OPC Private Limited, so that she can't form another OPC because of this point. Next one, prohibited business activities. The problem is here proposed business is non-banking financial investment. For that there is a prohibition by the company law, so that she can't carry the NBFC activities under one person company, so that she is not eligible for applying the OPC for non-banking financial investments. Then third point is appointing a minor as a nominee. Here minor is a incompetent person. He can't take over the company in case of any uncertainty, so that this one is another ineligibility, so that here she can't claim for the one person company. See, this is the conclusion to be given in your answer. See, her plan fails on three fundamental grounds. She is already a member of existing OPC, the proposed business activity is prohibited, and the intended nominee is a minor, so that she can't form a one person company. So that is the conclusion to be given in your answer. So this is all about some important topics of the second unit of the company law. So I also attached the file in the description part that you can check out. So in that you can find the relevant materials for your upcoming exam, that is a revision sheet, and also some more questions from different topics that you can refer for your upcoming exams. If you find this video relevant, then please do share it with your friends, and also those who are appearing for these exams. That will be helpful for their exams also. Thank you, students. Thank you, students.